Good evening and welcome to the program. First tonight, due process and transparency are integral to a fair and just society. It's heartening to see our new Attorney-General, John Rao, tackle the latter by agreeing to set up an independent commission against corruption in this state. But as for due process, after a decade of darkness, he still has some challenges to meet. On Sunday night, Channel 9's 60 Minutes program added their voice to that of the Seven Network and the ABC over the wrongful conviction of Adelaide father Henry Keogh. The confessions and admissions made by former forensic pathologist Dr Colin Manock on the program now make it impossible to resist the conclusion that Keogh's conviction was unsafe. Here's Graham Archer with the startling details.
Did you get it wrong?
In 2001, the ABC's Four Corners program first raised questions about fundamental errors in the conviction of Henry Keogh.
Dr Manock's slides from the bruising have recently been reviewed by Professor Tony Thomas. The results are startling and appear to cast serious doubt on the Crown case.
Over the next decade, we've revealed many more flaws in the way the case was investigated and prosecuted.
Would it have been possible, by the prosecution's theory, to drown a woman the size of Anna Jane Chaney?
If the head is kept straight facing upwards, certainly not.
A father jailed for 16 years.
This isn't just a story for us, this is our lives.
And now Channel 9's 60 Minutes has come to the same conclusion, having interviewed the man who put forward much of the flawed evidence, our former Director of Forensic Pathology, Dr Colin Manock.
The case against Henry Keogh may well have been flawed from the start.
Each program has queried Dr Manock's lack of qualifications when first employed.
He was unable to do certifying of the cause of death because of his lack in histopathology. We had a man who had no specialist qualifications doing a specialist job.
And a subsequent catalogue of errors, including the damning findings against him after he incompetently diagnosed the deaths of 3 horrifically battered babies, one with 15 broken bones, as having died of natural causes.
In 1993, a 9-month-old boy was admitted to Adelaide Children's Hospital. He was dead on arrival with horrific injuries from child abuse.
Allegations were made that I got it all wrong, and I admit, in one of the cases, I got slides mixed up.
That's a gross error, isn't it?
It is an unfortunate error, but one which can be made when things are hectic, and at that time things were very hectic. And I admit that as a mistake.
Of course, he's not telling the full story. There were 3 incompetent autopsies within a year of each other. With these failures hanging over him, Dr Manock went on to give highly suspect evidence against Henry Keogh, but the jury were kept in the dark.
Having conceded that you made mistakes on that case, why would we believe you that you didn't make any mistakes on Henry Keogh?
As most in SA know, Dr Manock's theory was that on the evening of March 18th, 1994, Keogh grabbed his fiancée Anna Jane Chaney above the left ankle, lifted her legs above her head and drowned her. He based this on faint bruising, the most vital of which was the so-called thumb bruise to the inside of the left leg, which he claimed completed a grip.
Standard practice is to take a section of that bruise and analyse it under a microscope. Dr Manock did that. It came back negative. No bruise.
Also essential to his theory was that the bruises had to have occurred simultaneously and just moments before death. Having told the jury they were, he now concedes he couldn't possibly tell.
When you say to me that bruise could have been 3 or 4 days before the murder, the whole case hinges on that.
No,
and it falls down on that.
The one tissue slide, which could have presented clear evidence of bruising, actually showed there wasn't any evidence of bruising, and that wasn't disclosed at the time of the trial.
So there was no bruise?
So we've got photographs of it.
One black and white photo was taken of this area. This is it. Photographic expert Professor Gail Spring examined the autopsy photos, just 5 in all, for Four Corners and Today Tonight, and concluded they reveal nothing.
If these particular photographs were shown to a jury, they would be absolutely irrelevant. You could not interpret those in any way without having a lot of other technical information.
You got photos of a bruise, but you don't know how long it had been there for.
No. It doesn't mean
so
to say.
It could have been 3 days before or 4 days before.
We couldn't say.
It may not have been caused during
That's quite
your
right.
theory about how she died.
That's quite right.
That's astonishing.
It is.
Shouldn't the jury have known that?
I gave the evidence to the best of my knowledge and belief at the time.
Did you say that the bruise could have been 3 or 4 days old?
I'm quite sure that in cross-examination those possibilities
I don't think there was. You weren't asked those questions for some reason. It was unbelievable that you weren't.
It's since been shown even his evidence for drowning as the cause of death is equally suspect. So with his science seemingly in tatters, Dr. Manock has abandoned objectivity to clutch at the circumstantial evidence.
Where's the evidence that he did it?
The evidence is that there was large amounts of life insurance on her.
It's only motive if there's been a murder. You have to prove there's been a murder, and from what I can see, there's no evidence of murder.
As an expert witness, he should never have allowed such speculation to influence his science. However, it's also crucial to know that despite the widely circulated view that Keogh must be guilty because of the forged insurance policies, a thorough examination of the evidence shows there's little substance to it.
If you think about it, to take out 5 life insurance policies in a very small town like Adelaide, to tell each insurance company that you don't have any other insurances, to then plan to kill a fairly high-profile person, and then go around each of those insurance companies collecting on them and expect not to be found out, I think is manifestly ludicrous.
There are documents which prove Anna Jane knew and approved of him creating policies to keep his insurance agencies from lapsing, a common practice in the insurance industry. If the jury were misled on the forensics, they were also seriously confused by the prosecution's presentation of the insurance evidence. It also deserves to be re-examined.
If he hasn't had a fair trial, he's entitled to have his conviction set aside, and he can have a retrial. That's all we've been arguing for.
More importantly, Sunday night is not the first time Dr. Manock has made such damning disclosures about his evidence. In 2009, he made similar admissions and concessions on oath before the medical tribunal.
He stated on oath that the evidence he gave at trial was wrong. Now, you only need one incident of that to occur to know that the conviction must be set aside.
For example, having originally claimed Keogh's left hand made the so-called grip mark, when he visited the scene, he found that that was impossible, so he simply swapped hands.
And from their position and shape, are you able to say which hand was used?
It would appear to be the right hand.
When we exposed this sleight of hand, he switched back, telling the tribunal the very opposite.
No, I don't believe the right hand was responsible for the grip mark on the ankle.
Was that a fair answer?
Well, plainly it's not, because Dr. Manock has subsequently given sworn evidence on many occasions that shows that that was not correct.
In all, on oath, he made almost a dozen new claims for which there was no evidence in an attempt to explain away the deficiencies in his work. The tribunal curiously excused him, but he's now exposed himself publicly on national television.
How many convictions did you get?
I have no idea. I don't keep count.
How many cases?
400 plus.
In fact, he conducted almost 10,000 autopsies, and we're aware when speaking to 60 Minutes, he blamed the trial judge, corrupt police, the coroner and the DPP for his mistakes, to name a few. And then he blames all of South Australia for being the nation's tip for dumping dead bodies.
South Australia is Australia's dumping ground for dead bodies, and if the body's found within South Australian borders, then the South Australian coroner gets to order the post-mortem.
Is it a worry, do you think, for you and also the legal establishment, that if they did review this case and Henry Keogh was released from prison, that they would look at all of your cases?
I really don't know. I'm too old to worry like that.
The trouble is, for Keogh, having exhausted his appeals before all this was revealed, now not even the High Court can offer him an instant lifeline.
In Australia, that we can't in the final court receive fresh evidence where, for example, it's compelling and it shows that the person is actually innocent.
Former High Court Judge Michael Kirby concedes that the only chance for someone in this predicament is to petition the State Attorney-General. But
there is always a risk in a country which unfortunately engages every 3 years or so in a law and order campaign in elections. It's always a risk that that can intrude into the completely dispassionate consideration of a case.
It's heartening to see that the upper house of South Australian Parliament has recently endorsed Anne Bressington's call for a Criminal Cases Review Commission, which, if adopted, would have the power to review cases that may have miscarried.
We know that there's a gap in the system. We know that this is lacking. We know that this is long overdue.
Of course, our new Attorney-General, John Rao, has the power to fix Henry Keogh's dilemma immediately by sending the case back to the court for review. After 16 years in jail, surely it's time to acknowledge these flaws and show some mercy.
And in the course of history, people will look upon this as a very dark moment in both legal and forensic science history of South Australia.
Dr Manock has refused to talk to Today Tonight, having spent the past 6 years suing us over our allegations that he deliberately withheld evidence in the case. That matter ended when the Supreme Court of South Australia denied us the right to defend ourselves. All our attempts to plead truth were blocked, and even though the court said that our defence of truth was sound, we were effectively stopped because the case had gone on too long. Ironically, 3 of those 6 years was spent waiting for various courts to deliver their decisions. But we stand by our claim that, having not disclosed serious gaps and errors in his investigation, Dr Manock did deliberately withhold evidence and did mislead the jury. What Channel 9 has broadcast merely supports what we've been saying, and that a serious miscarriage of justice has occurred. The clock keeps ticking on whether our government is comfortable about leaving any one of us to rot in jail for life, regardless of the case against us.
So, after investigations by the flagship programs of 3 networks and a decade of damning evidence, let's hope the light at the end of the tunnel is fast approaching. Graham Archer.